You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg terminal. Bill, welcome.
Good day.
So we have news of two large companies that chose to file their bankruptcies in jurisdictions other than Delaware or New York, where most big Chapter 11s, of course, are filed. I'm referring to Allan's, a vegetable processor, and Advantage Rent-A-Car, which has been part of Hertz. Bill, why did they go to these smaller jurisdictions?
I have an idea. See this? This is what a bankruptcy costs in New York and Delaware. See that? That's how much it costs in smaller cities. And here's what I mean. Allan's is a big-sized company. It's being sold, as a matter of fact, for $148 million. It's one of the country's largest vegetable packers. Advantage Rent-A-Car, I think, was the fourth largest rent-a-car business in the country. It was spun off from Hertz a couple of years ago. Fact of the matter is, it is very expensive to go through bankruptcy in New York and Delaware. The posted prices these days, and in fact the prices that are actually paid for partners in New York and Delaware is, get this folks, roughly $900 an hour to approximately $1,050 an hour. For associates, the charges run typically from $400 an hour to $800 an hour. But actually, when you see where the time is spent, most associate time is going to be in the $600 to $700 range. So that turns out to be extremely expensive. When you look at the rates that lawyers, even the very best lawyers, charge in smaller towns around the country, you see an entirely different picture. You see partners charging $300 to $400 an hour, and obviously associates a good deal less. So you can see right off the bat that the lawyer time for conducting a Chapter 11 case outside of New York and Delaware can be a fraction of what it is in the big city cases. And I am thinking, I don't have any hard evidence of this yet, but I'm thinking that the New York and Delaware folks are beginning to price themselves out of the market for what I'll call the mundane, albeit decent-sized cases, where you don't have to have the world's very finest practitioners to push somebody through Chapter 11 or through a sale very quickly. I'm just betting that this is the beginning of a trend.
Right, people have been talking about this for a long time. Really interesting to see it start to play out. Moving on, we have American Airlines. It consummated its Chapter 11 plan and merged with U.S. Airways, of course. I know that AMR shareholders kept some stock, but how well did they come out in the end?
You know, Lee, it may well be that in terms of the best outcome on a fulcrum security, AMR may set the record.
Really?
You could have purchased AMR stock for about 40 cents a share in October of 2012 because everybody figured it's the typical bankruptcy, stock is wiped out. As it turns out, Lee, based upon the price of the merged airline stock as of about now, that stock you could have purchased for 40 cents a share is now worth this, Lee, more than $17 a share. Even when the word was out that the American Airlines holding company was solvent and the stock would be worth something, you still could have purchased the stock for $1.30 a share before the merger with U.S. Airways was announced in February of 2013. So all of this means that people who took a sharp pencil to paper came out very, very nicely.
I'd say. We also have Loehmann's. The 70-year-old discounter is in bankruptcy for the third time. This time, unfortunately, it's a liquidation. Bill, how's it going so far?
Well, a little rocky. They appeared before bankruptcy judge Martin Glenn, and he didn't give them everything that they wanted. And by the way, before we talk about Loehmann's, it has just come to my attention that two of our very famous bankruptcy judges in New York are retiring.
Which ones?
I refer to Allan Gropper and to James Peck. Judge Gropper will descend from the bench in October coming, and Judge Peck will be out at the end of January.
Both great judges. I had the opportunity to work for Judge Gropper when I was in law school.
Yeah, he's nothing short of genius. And of course, it was Peck who guided Lehman Brothers through its very difficult, contentious, huge bankruptcy. Both those judges are going to be remembered for some of their very important opinions. For Gropper, it was one he handed down just about a week ago, where he tagged Kerr McGee for a fraudulent transfer in spinning off Tronox. He is yet to decide how much to affix in damages, but he said it's going to be somewhere between $5 and $14 billion.
Big transaction.
And in terms of important things that Jim Peck did, he's the one who wrote that decision that flip clauses in swap contracts are not enforceable in bankruptcy. That's a biggie. But, I digress, because, in fact, we were talking about Lohmann's. They came roaring into bankruptcy court saying, listen, this is our third bankruptcy. We can't do this anymore. This time we have to liquidate. And they wanted to have an auction on the 30th of December to select an auctioneer, or not an auctioneer, but liquidators, to run going out of business sales. And Martin Glenn said, no, you don't so fast. He said bankruptcy is not solely for the benefit of secured creditors. If the secured creditors want to do what they want to do at their own speed, well, then let them back up trucks to the stores, carry out the merchandise, and go sell it themselves, he said. But if you're going to use the bankruptcy process, we have to make it a little bit slower. It looks like he's going to slow down the sale process by about a week, which means that the GOB sales for poor old Lohmann's will not begin until sometime around the middle of January.
Yeah, sad end for a retailer that's been around for a long time.
Right.
Bill, let's take a look at the advance sheets. The Second Circuit Court of Appeals in New York wrote another important opinion on a Chapter 15 case. Chapter 15, of course, is the part of the bankruptcy law that deals with international bankruptcies.
Right.
I understand this decision was controversial. Why?
It is. It is. It is, in fact, the second controversial decision by the Second Circuit in this offshore transnational bankruptcy business. And in fact, both decisions that I'm going to mention very well could be wrong, at least in the view of some of the experts in the area. This new decision was called Drawbridge versus Barnett. This was a case in which the offshore liquidator did not allege that there were any assets or property in the United States. And the Second Circuit held, reading what they thought was the plain language of the statute, to mean that to have a Chapter 15 case in the U.S. and to get the assistance of creditors, you have to have property or assets in the U.S. And for that reason, this poor old liquidator found himself pushed out into the cold. This decision runs a bit counter to the notion of what Chapter 15 was all about in terms of having the U.S. bankruptcy courts provide assistance for bankruptcies primarily pending abroad. This basically means, tough noogies. If you don't actually have assets in the U.S., there's not anything you can do through the U.S. bankruptcy courts, even though you might want to come here, for instance, to take discovery to find out people that you want to sue. The other decision that they had about 2 years ago involved a hedge fund that was incorporated in, I think, in the Cayman Islands, but completely operated in New York. The decision there was that because the liquidation had been pending in the Cayman Islands for, say, 6 to 9 months, the center of main interest, or the nerve center of the hedge fund, had moved in the meantime from New York to the Cayman Islands, and so therefore the U.S. courts had to bow to the powers of the courts in the Cayman Islands. Both of these opinions have drawn, shall we say, careful review, if not criticism, by some of the people who are most versed in the area, professors and whatnot, who actually even helped draft the statute. So we just have a situation in here where the Second Circuit, sitting in its ivory tower, might well have paid a bit more attention to the people who wrote the statute before they reached their decisions.
All right, that's what we got. Bill, thank you. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just ran through, be sure to go check out Bill's column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates, of course, on Twitter. I'm Pacchia. Thank you for watching.